Have you ever looked out your window and wondered if your neighbor's incredibly noisy air conditioner is actually illegal? Or maybe you've wondered if they literally have the right to walk straight across your driveway? Well, welcome to this explainer on easements versus nuisances. You know, property lines might look super simple on a map, but the legal reality of what we can and cannot do near our neighbors is honestly fascinatingly messy. So today we're going to untangle that mess together.
Okay, let's take a quick look at our roadmap for this explainer. 1. The invisible property lines. 2. Understanding legal easements. 3. Creating and acquiring easements. 4. What constitutes a nuisance? And 5. Resolving property nuisances. All right, diving right into Section 1, the invisible property lines, defining boundaries and burdens.
To really understand neighbor disputes, we first have to grasp the invisible lines that dictate what we can and cannot do on our own land. Because it's never just about physical fences, right? It's about invisible legal rights. In property law, an easement is defined as an encumbrance imposed upon an immovable property. But what does that actually mean in plain English? Think of it as a legally sanctioned physical compromise between neighbors. It's a burden placed on one piece of land for the benefit of another. It basically means your property isn't a completely isolated island. Sometimes other people actually have a legal right to utilize a little slice of it.
Moving right along to Section 2, understanding legal easements, navigating authorized intrusions. Picture this. Imagine waking up, having just bought a beautiful piece of land, and suddenly realizing you have absolutely no way to reach the main road without crossing your neighbor's lawn. You are entirely boxed in. Legally speaking, you are landlocked. So, what happens? Are you just stuck there forever?
Thankfully, no way. The law solves this landlocked nightmare with what's called a right-of-way. This essentially forces a path open, allowing the landlocked property, which we call the dominant estate, to pass through. But wait, there's a major catch here. You don't just get a free driveway. The servient estate, that's the neighbor whose land you're crossing, must be compensated. You actually have to pay an indemnity based on the value of the land you're occupying or the damage caused by your passage. Now, what's really interesting here is the strict legal standard applied to that right-of-way. You can only demand a path based on the adequacy of needs, meaning it has to be truly necessary. You absolutely cannot demand a path just because it's a mere whim or convenience, like, say, just wanting a faster shortcut to your favorite coffee shop. The intrusion must be completely legally justified by necessity. And beyond a right-of-way, there are a few other common legal easements you should know about. Take light and view, for example. The law generally requires a minimum distance of 2 meters from the property line if you want to open windows for light and view. This basically prevents you from staring directly into your neighbor's living room. Then there's the party wall, the shared dividing line. The law actually presumes a party wall doesn't exist if there are exterior signs pointing otherwise. So if a wall is built entirely within one boundary or if there are windows opening through it, it's not a party wall. Okay, Section 3, creating and acquiring easements, time, action, and agreements. Let's see how these actually come to be. 10 years. In the property world, that is kind of the magic number. Under the right circumstances, you can legally acquire an easement purely by using it, uninterrupted, for a decade. It's a legal concept called prescription, and it essentially rewards long-established behavior. However, and this is a massive however, that 10-year rule only applies if the use is continuous and apparent. That means it has to be constant, it has to be visible, and it can't require constant human intervention. Take the famous Bogo Medellin case as a perfect example. The court ruled that a railroad track is discontinuous. Why? Because trains aren't incessant, right? They require an independent human act to drive them. Which means no matter how many decades that train runs, the use never ripens into an easement by prescription.
Now keep in mind you can always just bypass all the legal drama and create a voluntary easement with your neighbor. You literally just agree to it on paper to make life more convenient for everyone. And here's a fascinating quirk about voluntary easements: they do not automatically terminate, even if a brand new, perfectly adequate public road opens up right next to your house later on. A deal is a deal.
That brings us to Section 4. What constitutes a nuisance? This is where neighbors really cross the line.
So, we are officially leaving the structured, permanent world of easements and entering the chaotic, annoying disruptions of property law. What exactly makes something a nuisance? Well, the legal definition is incredibly broad. It covers everything from acts that injure or endanger health to things that simply offend your senses, like, awful smells or really loud noises. It even covers shocking decency, obstructing a public highway, or outright hindering someone's use of their own property. It is essentially the ultimate legal catch-all for bad neighbor behavior. And logically, this breaks down into two distinct buckets. First, nuisance per se. This is something inherently illegal that needs no formal declaration. Interestingly enough, the controversial Torre de Manila building wasn't considered a nuisance per se because it had secured the proper building permits. Contrast that with nuisance per accidents. These are situational and actually require a legal declaration. A really good example is the no-build zones established after Typhoon Yolanda. A house isn't inherently a nuisance, but in a post-disaster danger zone, it suddenly becomes one.
I absolutely love this ruling from Alita v. Sofitel. Let me read it to you. A swimming pool with a slide constitutes an attractive nuisance because the special features require special attention from the establishment to prevent damages. This introduces the concept of an attractive nuisance. Basically, if you add super fun special features to your property, you instantly take on a special legal responsibility to prevent harm, especially when it comes to curious kids.
So while that flashy pool slide is an absolute legal magnet for responsibility, you can breathe easy knowing your ordinary, standard-issue air conditioner exhaust is generally perfectly legal. As long as it's an ordinary activity and not totally out of place for the area, it's not a nuisance. It's really all about what is a special feature versus what is just standard.
And finally, Section 5, Resolving Property Nuisances. Putting a stop to the disruption.
Here is a massive, absolutely crucial difference from what we learned earlier. There is no prescriptive period for nuisance, none. Unlike easements that can be legalized after 10 years, time literally never heals a nuisance. If it's a nuisance today, it remains one forever until it's resolved. You can't just endure a toxic smell for a decade and then suddenly lose your right to complain. Okay, so how do you legally resolve the issue? You have to carefully follow these steps to abate it. First, identify if it's public or private. Second, strictly comply with the law for abatement. And third, and guys, this is so important, do not abate summarily without risking criminal liability. You absolutely cannot just walk over with a sledgehammer and destroy your neighbor's offensive property. You have to ensure strict compliance with the legal process so you don't accidentally become a criminal yourself while trying to stop a nuisance. As we wrap up this explainer, I want you to evaluate your own neighborhood boundaries. Literally, take a look out your window right now. Ask yourself, what legal compromises are you currently living with? Are you looking at a legally sanctioned easement that you just have to accept? Or are you staring straight at a nuisance in the making? Understanding the invisible lines of property law completely changes how you see the world right next door. Keep observing, keep learning, and I'll catch you in the next explainer.